when he's on probation, when he's got a strict agent, when he has treatment court or drug court. He does well. He's told me that himself.
We will go on the record in the matter 24 CF 228, State of Wisconsin versus Andrew Alden. The state appears through District Attorney Kevin Schmidt in person. Mr. Alden appears in person in custody with counsel Nicholas White. We're set here today in this matter for the sentencing portion of the case. Mr. Alden pled guilty on June 4th, 2025 to one count of possession with intent amphetamine, methamphetamine, greater than 10 grams, but less than 50 grams, a Class D felony. The court ordered a pre-sentence investigation report. The court has received and reviewed that report. The court has also received an alternative pre-sentence investigation report. I have also reviewed that report. I believe that was all that was presented to the court for its review. I do not believe that I found anything that jumped out to me that would be an error or a material error in the either of the reports. Mr. Schmidt, did you receive a copy of both documents?
I've received them. I've reviewed them. I have no corrections.
All right, Mr. White.
Thanks, Judge. I did receive both of these documents, filed the alternate PSI. The only errors or omissions that I noticed in the DOC PSI would have been the criminal history. And for the most part, that was updated correctly in the alt PSI on page 7. The PSI makes a couple mistakes of Mr. Alden's history. For example, they state that he served a year in jail. That's not true. He only served 3 months. So that'd be just an error on page 4. There's a number of just other kind of errors or clarifications there. With the case 20 CF 190, he did have an imposed and stayed sentence. Never had to serve that. And I would just, I guess, direct you to page 7 of the alt PSI that confirms things from CCAP. For example, Burnett case 2005 CM 74. I have no access to that case. Somehow DOC found it, but I have not been able to. Must have been expunged or something. And that's it for errors or omissions.
All right, thank you. Mr. Alden, did your attorney go over both of these documents with you?
Yes.
And you reviewed them very thoroughly?
Pretty much, yes.
And so the errors that Mr. White stated on the record were the only errors that you recalled or you were able to point out as well?
Yes. I've never sat this long in my life.
All right, okay. Mr. Schmidt, I'm going to turn to you for argument and sentencing recommendation.
Thank you. According to the court's PSI, DOC's recommendation is 8 to 15 in and 4 to 5 out. My recommendation is going to be towards the lower end of DOC's recommendation. It's going to be 8 years initial confinement, 4 years extended supervision. Going to be recommending that the court make Mr. Alden eligible for the substance abuse program and the early release program after being in custody for 4 years. When you look at the offense and the read-ins, it encompasses Mr. Alden possessed large quantities of methamphetamine on 2 occasions. Quantities and paraphernalia gathered indicated that they were for sale, not just for personal use. He also had a large amount of cash, despite claiming destitution and being totally reliant on a small amount of SSDI. That's suggestive of not just selling to support a habit, but selling to support more than that. I think the goals for this sentence as a result should be rehabilitation, specific deterrence, and general deterrence. So right off the bat, the sentence should not be probation. The court should strike that out right at the beginning. The reason why is in the past 15 years, Mr. Alden has had, by my count, 8 convictions, 6 of which ordered probation. He's been on probation for, from what I can tell, about 12 years. If a person is not only not getting better after that much time on supervision, but getting worse, moving from simple possession, which encompassed the vast majority of his criminal history, into actually dealing, then that shows getting worse over time, not getting better. It demonstrates that despite probation being the initial response in all these past cases, we're getting digression, not progression. So probation can't be the answer, especially if an offense is committed while on supervision. So with probation off the table, I think we're really talking about how much incarceration would be appropriate in this case. And another reason to know that incarceration, there has to be at least some of it, is obviously gravity of the offense. I think that just doing jail that is not prison would unduly depreciate the seriousness of the offense, which is the possession with intent. Sometimes with possession with intent crimes, especially if it's the first time the person's been convicted of it, we might consider that in those cases. But here, given it's two separate incident states encompassed in the offense and the read-in, I don't think that is appropriate here. I think such a sentence would violate the McCleary-Gallion factors and have a negative effect on the goal of deterring the public generally. So how did I come to how much prison we have here? So with Mr. Alden's priors, all but one of the priors were simple possession offense. The only one that wasn't was a receiving stolen property offense that was 14 years ago. The history tells us that Mr. Alden has an extremely pervasive, hard to defeat substance abuse disorder. Part of the reason probation should be off the table is because of that, because he's done everything on probation. He's done everything you could do for treatment in the community, and it hasn't worked. That means treatment in a confined setting is what would be ideal for Mr. Alden. And what's available in the county jail is not going to be better than what he's done on probation in the past. When I say the treatment in a confined setting that he really needs, I'm talking about what's available through the substance abuse program in the Wisconsin state prison system. That is the next graduated step up from a person who's done every conceivable program, who's done drug court, who's been on supervision numerous times. That should be where we go next. I think that's the best bet at actually curbing what is the driver, what you can definitively say is the driver, and at a bare minimum, all but one of his convictions, and probably very likely, again, it was receiving stolen property, probably involved with that as well, just because we often see a nexus between those. I haven't reviewed the specific facts of that offense, but we just know there's a connection between thefts and receiving stolen property and people having substance abuse disorder. So I think that treatment in confined setting, Wisconsin prison system, earned release program, substance abuse program, that's the next dosage up from what he's had so far. I think he needs enough prison to ensure that he can complete the substance abuse program in prison. He has an enormous amount of credit now. I think a statement, I can't tell if it's Mr. Alden or if it's Mr. White, who said this right now has been the most time he's been in custody. It is 366 days. So one day over an entire year already is what he's at. So if the court did a short enough prison sentence with that much credit, he might not even be able to do ERP because you need to be in long enough to do the program. And if there's a waiting list, to get through the waiting list first. I know being lower risk and I know being closer to the end of your sentence moves you up that list, but I think we need to make sure he has enough time for that. So that's part of why in my recommendation, I position the 4 years ERP eligibility at 4 years, because then we know he's going to be able to get through any waiting list, that he's going to be able to do the programming and actually be able to do it in prison, the substance abuse programming in prison, no matter how he gets categorized 1 through 4 on his risk assessment that the DOC does, no matter how long the waiting list is. I think that's something that's super important in this case, the ERP program. I'm probably getting repetitive with mentioning it. I think it's so important in this case. In terms of why am I arguing for 8 years initial confinement on this? When we have normally for a first-time drug dealing offense, I'd probably recommend something more in the terms of 3 to 5 years initial confinement, but I'd argue much less. I'd still argue they have to sit quite a bit of time before the ERP eligibility. In this case, like I said, since it encompassed really 2 acts at different times as part of one course of conduct, I thought it appropriate here 8 years. Because quite frankly, if I did charge this as 2 complaints, which would have been another choice, I think that's what we'd be talking about anyways, just given the multiple ways there can be for charging and viewing the behavior. So yeah, I think 8 years initial confinement, given what the maximum minimum penalties are, encompasses what I'd call a high end of a moderate sentence. It's right at the threshold before you'd say it's a big sentence or a small sentence for a high level offense. Say if somebody had 100 grams of methamphetamine. Yeah. I also think it's important here to not make Mr. Alden immediately eligible for the ERP program. The reason for that is I do think he needs some time incarcerated as a form of punishment for specific deterrence of purposes and capacitation. The large amount of money, the multiple instances of large amount of methamphetamine demonstrates he's been a larger problem in the community, so incapacitation has value in terms of protecting the community from Mr. Alden's distribution of controlled substances. I think specific deterrence is important here because of, quite frankly, how Mr. Alden kind of describes his own conduct in the court's pre-sentence investigation report. It kind of concerned me that he used phrases like being snitched out and describing about how he got caught, because that sort of terminology really suggests a belief that if the person who got you in trouble did something wrong, because snitching is a pejorative term for somebody telling you, it's a negative term for it. And it suggests that if they view that as problematic behavior or bad behavior, then it shows a different type of view of their own conduct rather than accepting responsibility. Like, I'm glad that person told on me. I'm glad I can put an end to this behavior. It's instead, I'm here because someone snitched out on me, which is not good when we're looking at terms of breaking criminal thinking, changing cognition, which is a really important factor, especially when even the sentencing memorandum from the defendant, when they went through their own compass, still showed Mr. Alden being pretty high risk, pretty high need in that assessment. It shows we don't just have substance abuse issues to tackle, we have criminal thinking problems to tackle. So that was something I wanted to draw attention to. The court might want to consider, no matter what it does, doing something related to mental health aside from substance abuse, just because of the incident of Mr. Alden trying to harm himself back in February in the jail. I think that would be something to look at as well. It could have just been related to fear of the consequences of this action or being incarcerated, as he explained, longer than he ever had been before. But in any case, it's probably a good idea to do that as well. Often substance abuse disorder is tied in with mental health issues as well. So to sum, again, I'm asking the court to do 8 years initial confinement, 4 years extended supervision. That's the low end of the court's pre-sentence investigation report. And to put the eligibility for ERP at 4 years, so because that's just what I think is the sweet spot for accountability and doing some specific deterrence with some time that's guaranteed in prison, and also making sure he can get the maximum benefit of the substance abuse program. Because if he's going to get rehabilitated, we've got to do what's new, and what's new for him will be that program, treatment and confined setting. Thank you.
All right, thank you, Mr. White.
Thanks, Your Honor. I want to go over just some of the charges here having to do with the gravity of the crime and work from there. This is a case that had a number of charges read in, and Your Honor, these are all items that were either found in my client's vehicle or on his friends or in his home, and that kind of area, maybe garage and on his property. He did admit to the count two, specifically because the count one there, although it is dismissed and having been read in, it's pretty clear, even just reading the complaint, depending on how much of this you believe, that item related to count one belonged to Mr. Timothy Frisco. He even told the officers that, and I think it's made more clear from review of the discovery. I heard the prosecutor refer to that charge quite a bit and this having multiple dates. Your Honor, those items belong to somebody else, and that's not the charge that we're here to sentence on. Just going from there, this is serious given the amount of items, even just something as simple as paraphernalia. There is a volume of that found in Mr. Alden's home. I'm not sure what the comments about a large amount of cash refer to. I thought there was only $500 here, and what's that?
I think it was 500 or something.
I believe that his bond was much more than that. I wouldn't consider that much money myself. This is not a case where you have a person who is dealing out of his house repeatedly. We don't have CIs going there to purchase. This case was effectively initiated by the comments related to snitching or Mr. Frisco pretending to be Mr. Alden's friend when he was really a CI. And that's how that arrest started, and I think it was a basis for the search warrant for the home search on October 3rd. We would recommend that Your Honor consider a mixture of what my author recommends in the all pre-sentence investigation. He looked into drug court and just the history there where Mr. Alden did succeed. That's referenced in the DOC PSI as well, that when people are strict with him, when he's on probation, when he's got a strict agent, when he has treatment court or drug court, he does well. He's told me that himself, that the times that he succeeded on probation, he had stricter agents. They didn't let him get away with as much, and that is to his benefit. My notes here is that he has 2 felony prior convictions, 7 misdemeanors, that he was put on probation 6 times, and he was only revoked once, and he was only in treatment court once, and he succeeded. It seems that he does succeed on treatment court. He does succeed on probation. We're not recommending probation today. I think that the seriousness here, Your Honor, just to be honest, this has to be a prison sentence, but we're asking for you to consider something a little bit less. My author suggested a 5-year total prison sentence, split evenly, which would be 2.5 years of confinement, 2.5 years of supervision. And that's what I'd ask you to consider for today, and to also include a treatment court component upon release. The concern there might be just that if Mr. Alden is on treatment court in Burnett County, it doesn't allow him to leave the area. And after looking at the PSI, that's something I think he really needs to consider, is either relocating or starting over with a new group of people. He is somebody who does not stick up for himself, and I don't know if that's just his life history, but he does have a lot of history of PTSD and bullying since from when he was a child. Both reports suggest that he has a very difficult time saying no to somebody, and that's not good when he's around people that are using or dealing. They expect things out of him, and if he doesn't have it within himself to say no, he's going to be in worse situations. Looking at his character and rehabilitative needs, he has well, he has some mental health issues, and he's got some learning issues here. I think that the list here of anxiety and depression, PTSD and ADHD from when he was a child, and then that just increasing to severe depression, physical problems like a hernia and heart problems. These are things that I think are just going to be made worse by the prison sentence and the prison setting. Particularly the depression, Your Honor, is my personal concern there. After hearing about Mr. Alden attempt to take his own life in this jail, and my own belief this jail is not as bad as what prison's going to be like for him, I'm concerned that Mr. Alden truly might not survive his time in prison, either anxiety related to heart issues and those combined, or just the depression and his own lack of self-esteem, and that combination is going to make this a very tough sentence for him to serve. The Compass report or assessment there had him at a higher risk, but it was not aggravated. And I think that's where the prison recommendation is necessary here, for better or for worse, from just from a sentencing point of view, but also for Mr. Alden's own benefit. This is a prison case, but it's not aggravated. So, Your Honor, I'd ask you to look at the smaller end of the sentencing there. And kind of just to finish up some of the conversations I've had with Mr. Alden, we've talked about him only ever serving 3 months in jail before. That was an important correction to the PSI, just because we know sentencing should be somewhat graduated. If Mr. Alden had never been on probation before, I might recommend it today, but he's had it, he's had chances, and we're recommending prison, but he's only ever served 3 months up until now. He's had the last year in custody outside of a short furlough for medical reasons. He's had a year in confinement to sober up, to start changing his outlook on life, to learn the lesson. We'd ask you to consider ERP upon immediately, that he'd be ERP eligible through the substance abuse program. I'm making that recommendation, but I actually did not factor in any kind of prison wait time with that recommendation. And I would trust the prosecutor's assessment of that independently. But looking at my client's goals, whatever Your Honor sentences him to, it's not going to be indefinitely. Looking optimistically that he survives prison and he's released. He's going to either have to sell his house and move, likely live with someone related to him, live with a family member if he can. But like I already commented, he needs to consider relocating and finding somewhere else. He doesn't have to work. He's likely not able to work because of his disability. He's had the SSDI for quite some time. As the alternate PSI author noted, unfortunately, that's really to his own detriment. As nice as it might sound to get this check in the mail every month for not having to work, in the long run, by not working, it gives Mr. Alden just too much time on his hands. This has not been something that he's used appropriately. And I think that's part of the reason his criminal history is the way it is. We've talked about his schooling. He was close to finishing high school and then moved and found out that it would take a number of years to complete it. So he never went back for GED or HSED. I think he needs to do that. Not necessarily to go out and find a new job, but just for his own mental health and development, maybe his own self-esteem. I think it could help him out there and thinking through things. We've talked about therapy. He's admitted that counseling has helped him a lot in the past. He was in treatment with Whole Life Services at some point, I think in 2024, before this arrest. He's currently been accepted into treatment at Salvation Army. So he would have options for either just counseling, mental health help, or actual substance abuse therapy afterwards. While he's been in custody here, he has attended the anonymous meetings when it's been available. Sounds like there's just an issue with numbers once in a while. Your Honor, I reviewed both of these recommendations, and I'd ask you to consider that the best recommendation, sort of a combination of these with a short confinement portion and likely a requirement for him to at least apply to a treatment court with wherever he's going to be supervised upon release. That's all I have for you, Judge.
Thank you, Mr. White. Mr. Olden, would you like to make a statement here today? You do not have to, but it's your only opportunity to let me know anything you would like me to know, anything that may not have been stated by either side, or to correct some things that may have been stated as you believe to be incorrect.
Your Honor, I have said this is the longest I've said. I've truly learned a valuable lesson here. And I feel your treatment court, with the little help with you in your treatment court, I can stay focused on my sobriety. I could stay with my parents, and my house has been cleaned out. I'm ready for it to either be rented out or up for sale. So I won't be returning back to there. I think a new place to live would be best for me, or somewhere new. And you know, even if having no contact with any known users or anything would help. I know that. Yeah, that's about it.
All right, thank you. Thank you, Mr. Olden. Mr. Olden, the first thing I want to let you know is, well, you've been in front of the court various times for nothing as serious as this. And as you've stated, this is the longest time you've been incarcerated. The longest was 3 months. There is a vast difference between 3 months and 1 year of incarceration. There's an extremely bigger difference between jail incarceration and prison incarceration. Some things, I've had people say, some things about prison are far better than being incarcerated in jail. Some things are worse. But still, it's prison, and it would be your first prison sentence. In order for you to be on a better path, a different path, you have to change your habits. You have to change your associates. You have to change yourself. And in doing those things, you can significantly improve your life and not be in that seat wearing orange again.
That's what I would like to do.
You need to not only modify your personal habits, but you have to actively surround yourself with people who support a positive change and that align with your desired goals, the goals that your attorney listed that you have for your future. You have to realize that the people that you spend time with are the people that greatly influence your behavior, and they influence your mindset. So if you're with positive people doing positive things, making a positive change in this world, you will align with that and be more positive and have a better, less criminal-filled life.
Yes.
But if you gravitate back to the people you have associated with, and I'm just going to say back to 2017, when I believe that was when I first met you, or somewhere around then, that you gravitate to those people that you have continued to gravitate towards, your life is going to continue to get worse and worse. And it is a fact that once you go to prison, and if you are on ES, extended supervision, the more you continue to be around those people, the easier it is, and the more likely it would be that you will go back to prison. So you need to be in a place today and in the future to make those changes, to change your habits, to change your associates, and to change yourself. You've been here before in front of the court in which I have went over the certain things and factors that I have to review with sentencing. The first and foremost is the nature and the gravity of the offense. Again, this is the far most serious crime you've been in front of the court for. Otherwise, it's been possession of methamphetamine, maybe the criminal damage to property. I just recall a handful here or there cases of possession of methamphetamine, and some were reduced to possession of amphetamine, but things that were less serious. We all acknowledge, every person in this room acknowledges the severity of this offense, the intent to deliver the amphetamine, methamphetamine. And here we have 2 counts greater than 10 grams, less than 50 grams, Class D felonies. Each count carries with it a possibility of 25 years of incarceration apiece. And I know that there's argument, and I've heard from your attorney, and I know that you've argued the fact, and I've read it both in the alternate PSI as well as the DOC PSI, that with regards to count 1, that you argue and you're saying that that was not yours. You were in a car traveling with this other person, you were pulled over, and there was methamphetamine, I believe, found under the seat. And that person at that time stated, "That's my methamphetamine. It's not Mr. Olden's, it's mine." But then through the process of his case and his work with the police and their investigation, then it switched. And his statement, and especially like with this case, showed or proved that it was your methamphetamine and that you were selling and dealing methamphetamine. I know that you argue otherwise, but either way, this is a dismissed and read in count, and the court can consider that for sentencing purposes and any restitution if there is any, but for sentencing purposes, as long as the court does not exceed the maximum possible penalty for the charge that you have been convicted of. I also have to look at your character and all of that with your criminal history and what I have in front of me, what I know and what I have in these reports. I have to look at needing to protect the public. And here, this is a community, this is a public as a whole seriousness case and needing to protect that community as a whole. And as Mr. Schmidt did state, that there are other factors for the court to consider as well. I have to consider your rehabilitative prospects. Do you have the ability to rehabilitate? Do you have the ability to take services, learn from those services, make improvements in your life, and correct your behavior and your mindset? Do you have this undesirable behavior pattern? Is this something that the court has to be worried about? Is this something that you've been engaged in previously? I have to look at your culpability, your age. I have to look at your education, your past, and that's where the other things like the trauma and the mental health and what you've experienced in your life comes into play. I also have to look at deterrence. And Mr. Schmidt pointed this out in his argument to look at general deterrence, what a sentence would do to generally deter others, other people who are considering or thinking of or actually engaged in this type of conduct, and specific deterrence, a sentence that would specifically deter you from wanting to or having any desire to or any thoughts of engaging in a crime like this again, or any crime for that matter. So the general deterrence of the whole and the specific deterrence of you personally. I have listened to the arguments of both of the attorneys, and I've heard you in your statement, Mr. Alden, you're not a man of many words, and that is okay. You have stated to the court what you want the court to be aware of and included in it a part of your plan and what you want to see in the future and how you want to change your life. I have read both of the reports and considered them, and I've actually reviewed them more than once. You have admitted, and you are admitting today, that you did in fact engage in the delivery, the sale of methamphetamine. And that is a very serious crime. It's on the top of the list of seriousness because, as you know, and as everybody else does in here, not only is Burnett County having an epidemic of an increase in substance abuse use or substance use abuse, including deaths and other things, but our state is, our country is. And I don't know how to get a hold of that. I just don't. And that's why the focus then becomes on the dealers and how to stop the dealers to hopefully stop the moving of those substances to people. If you look at the charges that you have originally were originally charged with, and if you look at the fact of if this matter were to have went to a jury and you were found guilty on all of those counts, you would have hanging over your head a little over 57 years of incarceration. 57 years. At your age, Mr. Alden, that could be a life sentence, even though some of it's initial confinement and some of it's extended supervision. But we know, or maybe you didn't know, but I will explain it to you, that extended supervision is kind of like probation, but different in the fact that if you violate, you can be revoked off of that and be sent right back to prison and serve the remaining extended supervision time in prison. So that makes it more serious and something to think about a lot more when you are out of prison and on ES. So 57 years is a lot of time to hang over your head. You did reach an agreement with the state in which you pled guilty to one of the very serious matters. And in doing so, you limited the amount of exposure to a maximum of 25 years, 15 years of initial confinement and 10 years outside. So you did get a good bargain in your plea deal. The primary dispute here is not whether or not you're going to prison. We all agree this is a prison case. The dispute becomes for how long? How serious is this? And does the court put a heavier weight on the fact of the dealing of the methamphetamine or a higher weight on the fact that this is your first serious crime, your first lengthy time of incarceration, and those other factors of your history? And that's for the court to work through with regards to this sentencing. I've heard a few things here today, and I want to make sure that I can touch on them so that you can have an understanding of where the court is coming from with its sentencing. First and foremost, I need to make you aware you will never be able to be a part of our drug court, our treatment court, because we do not, it's prohibited to allow people who have engaged in the sale, the delivery of methamphetamine and or any other illegal substance. So dealers are prohibited from being in our treatment court. So that is out, okay? But it does not mean that you would not be able to perhaps be a part of another county's treatment court, but you have to live in that county when you are released from extended supervision and if your probation is transferred, okay? You had a gift provided to you previously when you were a part of the Burnett County's treatment court prior to me, and you successfully graduated. That is a very positive thing. I don't know what happened. I don't know if it was your associates. I don't know if it was your trauma. I don't know what it was, but something brought you back to methamphetamine. Something brought you back to your addiction. That is what you need to figure out, Mr. Alden, Because until you figure that out and you have all of the self-reflection and you understand the impact of the events that have happened in your life, you will not be able to break your addiction. You need to be the one who takes control of your life. You need to take control of your substance use. Only you can do that. No one in this room can do that. Your mother has been here, I think, every single hearing that you have been in front of the court. She is a very strong advocate for you. She has been a strong advocate. She is in your corner. She will always be in your corner. And I'm going to tell you, I know from history, just living in this county for my whole life, that she was a very successful social worker in this county for a long time. And I can't believe that she would support your substance use. I believe that she is a strong advocate of you getting the treatment and the help that you need and reaching out to those people, including your mother. And I can't see that she would allow you to continue to use and to be in her home. So that would be a positive thing if that comes down to it when you are released. Or again, your thoughts of moving outside of this county are not a bad thought either, away from the bad associates. Change your habits, change your associates to be able to change yourself. I do see that you have rehabilitative prospects. You want to succeed. I have seen that in the history with your treatment court, those types of things. I believe, I didn't have to have Mr. White tell me, I believe that you are a person who has a very difficult time saying no. And I don't know how you got into the game of selling illegal substances. I don't know how you did. But I do believe it probably comes from a lack of the self-esteem and not being able to say no. I know I read in one of these reports that it was it wasn't inferred, it was stated that you were selling to support your habit. I can understand that statement. I can understand the fact that you don't have much money. It's not like you drive a brand new vehicle or you have all of this money to go on trips and to do concerts. But I don't believe the statement that I don't believe anybody's statement that they're selling to support their habit. Because selling methamphetamine is killing our county, it's killing our people, and you have been a part of that problem, a part of that devastation. And that's the awful part, because you engaged in this type of conduct, you are not only hurting yourself, you're hurting your mother, you're hurting your father, you're hurting your friends, you're selling to your so-called friends, you may be selling to any real friends, or other people's children, or other people's parents. And it doesn't just affect you, and it doesn't just affect that person that you have sold the substance to. It is more than a trickle effect. It's a waterfall effect, and it continues to destroy household upon household upon household. And I think you understand that. I don't think it's something that was in the foremost part of your thoughts, but I think you get that. And now you have a better understanding, because now you're sitting in that chair knowing you're going to go to prison. Hopefully today, and what's going to happen, and hopefully my words, the words of your attorney and of the state, will resonate within you. You will think about that, and you will be able to actually turn your life around and to change and to be an advocate. I have seen people sitting in that chair turn their whole life around, find God. I'm not saying you have to find God, but find something they believe in, find a purpose, and they become the biggest advocates for those who are in need, who have the substance abuse issues. And you could be one of those people, Mr. Alden. So when I'm looking at the community, I have to figure out a sentence that is not only going to be a punishment factor, a deterrent factor, but also one that is going to protect the community. So it does have to send a message. And it has to send the message not only to you, but to the community. I do take into account the trauma that you've experienced from a very young age, being burnt. I think it's on your neck. I think I can see it. You've healed pretty well over the years, but that was 20, 30 years ago, a very long time ago. But that had to be significant for you, and that did have to cause significant trauma. And that's why I can understand the PTSD and from the bullying that you had as a young child. Honestly, I'm going to tell you, as an adult, you probably experienced that as well. And you're shaking your head up and down that you do and that you have. And that could have been part of the factors for you to engage in the behavior that you have. I do have to state, though, that with regards to the dealing and the selling, you're in front of the court for the first time for this crime. But in this case, you have done it once and you have done it twice. And arguably, statistics would show that if you've done it once, you've done it twice, you've been caught twice now in this case, that it's more than likely that this is not the only 2 times that you have sold methamphetamine. You've just gotten away with it. And that's part of the problem too. And I want to say that's part of the problem for you, but it's also a part of the problem for the community and for others who engage in this type of crime. Because had you gotten caught earlier, perhaps, I don't know when you started, but years ago, let's say, you probably would have had a harsher sentence and it would have come down a little bit quicker. You could have turned yourself around at that time. And perhaps at that time, you wouldn't have had the criminal history you do now. And perhaps it would not have been a prison recommendation. Because I don't know, I have no idea when it started, and I'm not going to ask you and I'm not going to have you tell me. But let's just say 5 or 10 years ago. 5 or 10 years ago, we didn't have this epidemic. We didn't have this problem that we are experiencing today. It would have been a different punishment, a different sentence. Had you been caught earlier, perhaps you would have already turned your life around and you wouldn't be facing such harsh recommendations for prison. That's just unfortunately food for thought. And that goes with anyone who's engaged in this type of conduct. So, Mr. Alden, I have seen you over the course of the many years, and I don't know you personally. I just see what I get to see in court, and I see how you are with your family and your friends or the other people who hang around you or have been with you. I know you've said in other cases, you've let people crash at your house and just stay at your house because they needed a place to stay. So it sounds like you have a good heart and you want to do what's right. You just haven't had the courage and the strength and the self-confidence to do so. Perhaps even the self-esteem to be able to do so. And hopefully with this sentence, you're going to be able to gain those things. So with the seriousness factor and the protecting of the public, what the court is going to do, again, I have one sentence recommending 8 to 15 years of initial confinement from the Department of Corrections, 2.5 years being recommended by the alternate PSI and from the defense, and I have 8 years being recommended by the state. And the state also has the caveat of having you sit 4 years in prison before you can engage in the substance abuse. I do want, then that's the early release programming. I do want to tell you up front that generally, I'm not saying in every case, but generally with intent to deliver substances, in particular, anything over THC, the court, I don't grant the ability to partake in and engage in early release programming because it's such a serious offense. And that's generally, it's not a straight across the board thing. And I say that because in this particular circumstance, I am, because you need it. You absolutely need the substance abuse treatment program in prison in that setting, because hopefully, maybe that's what's going to stick. Okay? So with the recommendations that the court has in front of me, I'm just looking at all of my notes to make sure that I have covered all of the things. And I do want to state also, you pointed it out, Mr. White, that when in Mr. Schmidt's argument, he said, I think enormous or significant amounts of money. I only could find in my reading of the reports and the criminal complaint, it was $500 in the trunk of the car. And I can't guess, 200 or something in his pocket. And to me, and I can go count it, it identified each and every bill that was in his pocket, 15 20s maybe, or 15 ones, not something too significant. But it is a lot of money for a person to just have on their person. And I do understand that in one of those reports to one of the people, you did state that you kept the $500 in the trunk of your car because you didn't want it to get stolen. You were saving for a new car or something along those lines.
Register the car, yeah.
I don't know if I buy that, because I'm going to tell you, and you should be aware, everybody should be aware. It's so much easier for people, and it happens a lot in Burnett County, to steal somebody's car than it is to rifle through and go through every nook and cranny of a person's house. So it's probably easier for you to hide your $500 that you're saving to get a new car somewhere in your house, in a floorboard, in a wall, and to be able to build something in there, than it is to put it in the trunk of your car. So that's why that doesn't seem so realistic. And that's why that goes along the whole lines of the dealing. But again, putting everything together, I think I have covered all of the things that I wish to cover in this case. So what I'm going to do is I'm going to order 6 years of initial incarceration with 6 years of extended supervision. And I'm going to state that you have to sit at least 1.5 years of confinement in prison before you engage in the substance abuse program. You need that punishment portion before you have the ability to engage in what you really truly need and to be able to get out early. The earlier you get out, the more, and the time that you have remaining on your initial sentence goes to your extended supervision. But again, I warn you, it's easier to be revoked and sent back to prison once you're out. So change your life, change your habits, and don't be with the people you've been around.
Yeah.
They use you. And so be a person, it's good to give, but don't let them use you. $518 in fines and fees. And quite honestly, I'm not even concerned that that gets paid until after you're released from prison, but the Department of Corrections has the ability and the right to collect at any percentage that they determine to be reasonable while you're in prison. So that fights for you in the Department of Corrections. But this isn't restitution, so I have no qualms about it being until it waits until you are released from from custody. As part of your extended supervision, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, regular drug testing. I don't think you drink alcohol, but you're not going to be able to drink alcohol either, being on extended supervision. I'm going to order a mental health evaluation and follow through. And this includes therapy until your agent or your therapist releases you from the sessions, okay? Because you truly do need this. You do. You need to find you and you need to find your strength. No contact with anyone who's on felony drug-related extended supervision or probation. And it's drug-related, not just dealing. I'm also going to order a medical health evaluation with a medical doctor to go over whether or not you should look at some type of anxiety prescription or depression prescription or something along that nature, and to take those as prescribed. Because, Mr. Olden, it's not a negative thing to have to take medications for those conditions. So many people do. So many people do. Just like therapy. I think everybody should go to therapy. It would benefit everybody. But to take medications as prescribed. To continue with your treatment, and that could be finding a different drug court that may allow it if you're going to move to another county, or a inpatient treatment facility or outpatient treatment, just to continue your treatment alternatives, okay? And that will be with you and your agent to determine. You have 366 days of jail credit. If you fail to pay your fines and fees, not only will the court enter a civil judgment against you because you're always going to owe it, but the court could issue a warrant. You could sit up to 6 months in jail. I need your DNA. Then you will need to provide that to the jail. They will make sure that they have that. In this level and seriousness of a crime, I do not think you can have it expunged from the system, but you can request it if you wish through a written letter to the Department of Justice, not the court, to the Wisconsin Department of Justice. It's easy to do. Google or Mr. White could help you. They make that determination. This is a felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. I would like to see you find a hobby too. And I am going to make that a condition when you are released from custody. Find a hobby, one that you can engage in and you can partake in, that maybe it's weekly, maybe it's bi-weekly, because as Mr. White said, you have too much time on your hands. Idle hands are the devil's workshop. And you have shown that. You have done that. Because you have so much time, you get bored and you find friends and they haven't been the best and they've brought you down. So find a hobby. I don't know what it is. I don't know what you like. Hopefully you can think about it. Maybe you like to whittle wood. Maybe you like to paint, or maybe you would like to garden, something like that, and engage in a club or some type of other group that you can explore that and build upon that. Because, you know, maybe it's something that you like and you decide that you can whittle art and you sell that. That's additional money on the side that you can have.
Yeah.
So that's, I think, all that I am seeing right here. Mr. Schmidt, am I missing something?
I have two questions. One, is it the court's intention for the ERP that Mr. Alden is not eligible to start program till 1.5 years, or not eligible till release in 1.5 years?
Not eligible to start from 1.5 years of in custody in prison.
That, I think that kind of answers what my second question was going to be. Is it the court's intention to count the 366 days credit for the 1.5 years?
No.
Okay, that's all.
Mr. White.
That clarifies everything, Judge.
All right. Mr. Alden, I know that this sucks for you today. I know it does.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.